So we got a guy here with a fez and the last name Bay. So you just know that that's going to be juicy. Now, I've heard a lot of gibberish in court before, but this is about as good as gibberish gets in these scenarios. How this guy thinks that he's going to get away with any of these really serious charges just because he claims I don't actually know what he's claiming. It's absolutely beyond me. Let me get a good old nickname for this fella.
All right, so Mr. Hensley, I think I see where we're at now. So it looks like court denied a motion to stay proceedings on January 23rd, and then there was an order from the Court of Appeals on January 26th. So 3 days later, it looks like that your claim of appeal was dismissed. And then you filed on February 9th a notice of appeal to the Supreme Court. Trying to find the exact verbiage here of your motion. The motion to stay execution pending appeal of the bond to be waived. Okay, so we can hear that quick then, sir. I do have to go through these series of questions. You probably know them by now as well as I do, but I still have to ask them all, and we'll have to go through all of that, sir. So if you raise your right hand, I'll have you sworn, Mr. Hensley Bay. Sir, do you solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
I affirm.
All right, you can put your hand down. All right, Mr. Hensley Bay, as I've noted, we've gone through this several times. I just need to find our list here. But you are appearing here today representing yourself. And is that what you'd like to do today, is to continue to represent yourself on the motion that you have filed asking for a stay of the proceedings?
Yes, I do present myself, yes.
All right, but you wish to continue to represent yourself, is that accurate?
Yes, I continue to present myself, yes.
All right, and then Mr. Hensley Bay, do you understand that representing yourself can cause you to be at a disadvantage, particularly as it relates to the people who are represented by attorneys? And recognizing that you could be at a disadvantage, you continue to wish to represent yourself. Is that accurate?
Correct.
Okay. And Mr. Hensley Bay, as I mentioned before, that if you wanted to, you could ask for an adjournment. I'd actually grant you that adjournment. If you wanted to hire an attorney, are you waiving your right to go hire an attorney then?
If I need outside counsel, I can get it. Gratitude.
Okay, but you're not requesting an adjournment to go hire an attorney and have them represent you on this motion, are you?
No, I'm not.
All right. And you also understand that if you were eligible, you could petition the court for an attorney at no expense to yourself. Are you waiving the right to request court-appointed counsel?
At this time, yes.
All right. And this, Mr. Hensley Bay, do you understand that if you go forward representing yourself again this morning, as you have in the past, that the court is going to be required to treat you the same as I would any other person appearing before the court, whether attorney or not? Do you understand that?
I do not, but
Well, when you say you do not, we've had that argument before in a motion, right? So you're referring to the idea that you thought that there was a case out there that would suggest the court has to give you a lot of deference or wide latitude because you're representing yourself. Is that accurate?
Yeah. Kearney versus Hand, yes, ma'am, yes.
All right. And then we have debated that in the past. The court has denied that, saying that I don't believe the case stands for that proposition. And then if you go forward today, again, I'm going to have to treat you the same as I will Mr. Butler or any other representative from the people. Do you understand that?
I comprehend, yes.
Okay. And then Mr. Hensley Bay, again, I'll remind you that the charges that you're facing are serious. Those are 5 years of incarceration. That's a maximum penalty on the carrying a concealed weapon charge. Up to 4 years of incarceration on the assault, felonious assault charge. And then the big one here, this felony firearms is a charge that carries a maximum penalty of 2 years consecutive with and preceding any term of imprisonment. So again, explaining that you'll have to serve 2 years, no discretion by the court or anybody else. It has to be 2 years before you begin serving any sentence that would be associated with 1 and 2. Do you understand that those are serious penalties and that there are risks by you continuing to represent yourself? Do you understand that?
I comprehend. So the time went up on the charges, or because the last I was heard, it was 2 years, 2 years. So now one is 5 years.
Count 1 is 5 years. Count 2 is 4 years, and count 3 is the 2 years consecutive to 1 and 2.
I heard nobody.
Same penalty that I've read to you over and over and over.
Yeah, I don't remember the numbers being that large, but okay.
All right, but I have to give them to you again today, like we have, and you still wish to go forward on your own? Is that accurate?
I still present myself.
Very good. Do you understand that as it relates to rules of evidence, court rules, that if you continue to represent yourself, the court will have to hold you to those rules, just as I would any other attorney appearing in the courtroom?
Well, is that the same as you talking about my constitutional rights when you say the court rules?
Yeah, you certainly have constitutional rights, but as it relates to the court rules, the court will have to hold you to those like I would anybody else, including attorneys. So in other words, I can't give you some wiggle room on deadlines or something like that that might be found in the court rule. I have to hold you to the same rules. Do you understand that?
Mm.
You understand that, Mr. Hudson Bay?
Can you repeat that one more time for me, please?
Sure. I'm going to get Mr. Franklin in a breakout room here while we're doing that. There we go. I think we got it squared away. All right, so Mr. Hudson Bay, back to the question at hand. Do you understand if you go forward today representing yourself that I have to hold you to the same standard as it relates to court rules or rules of evidence or anything else as I do attorneys? Do you understand that?
I comprehend.
Okay. And knowing that you still wish to go forward on your motion today representing yourself? Do you want to go forward representing yourself today, recognizing the court has to hold you to the same rules?
Yes.
Okay, very good. All right. All right, Mr. Butler, do you believe the court's complied with 6.005?
I do, thank you.
Okay. I do find that again this morning, Mr. Hensley Bay's waiver of his right to counsel and his request to continue to represent himself has been done knowingly, intelligently, and voluntarily. It's unequivocal. And I think the court also can rely on the prior times Mr. Hensley Bay has been in this courtroom. It's been numerous. His answers have always remained the same with his desire to represent himself. He's always acknowledged that if he did need counsel, he would retain counsel, or that he would exercise his right to request court-appointed counsel. The court's also satisfied that it has, again this morning, explained the dangers of self-representation to Mr. Hensley Bay and that he'd be held to the same standards as other members of the bar or other individuals appearing before the court. So I'll allow him to continue with his self-representation. And then Mr. Hensley Bay, you're welcome then, sir, at this time, then to give the court any argument you'd like on your motion here that appears to be a request to hold the proceedings in abeyance, a stay, pending your request for the Supreme Court to look at this matter. What would you like to state in support of your motion, sir?
Excuse me, pain. I'm coming. Yeah, I'm just gonna read my motion. Defense motion for stay of execution pending appeal and bond to be waived. Come now, Milton Hensley Bay, in aforementioned case, with a motion to stay. Defendant move for an order staying execution of or any proceedings to enforce the final dispositions judgment entered in favor of Ione County Prosecutor Kyle Brandon Butler on January 8, 2024, pending disposition of defendant's appeal, which was filed with the Michigan Supreme Court on February 8, 2024. Defendant further moves that as defendant is indigent, no superseded bonds be required by the court, or if one is required, that no sureties be demanded. This motion is based on MCLA 600.2605 on MCR 3.604L. In support thereof, I am writing to request a stay of proceedings pending appeal in the above mentioned case. The purpose of this motion is to prevent irreparable injuries to the defendant appellant if the request stay is denied without causing harm to the appellee or the public interest if the stay is granted. Nature of irreparable harm. The denial of due process during the trial proceeding has resulted in specific irreparable injuries to the defendant appellant. The right to a fair and impartial trial is a fundamental aspect of due process under the Constitution. The denial of a continuance and the subsequent trial proceeding, which precluded critical evidence, have impeded the defendant appellant ability to present a robust defense. Denial of continuance. The defendant appellant motion for a continuance pending discovery was denied. Limiting the time available for adequate trial preparation, this denial directly infringed upon the defendant appellant rights to present a meaningful defense. Trial preclusion of evidence. During the trial, the court's ruling led to the exclusion of critical evidence sought by defendant appellant. This adversely affected the defendant's ability to mount an effective defense and deprive the defendant of a fair and impartial trial. Potential for sentencing before mandate. A particular concern is the risk that the trial judge may issue a sentence before the appellate court can issue a mandate. Such premature sentence would cause irreversible harm to defendant's appellee, as the appeal process may subsequently reveal errors or injustice in the trial proceedings. Lack of harm to appellee and public interest. Absence of harm to appellee. Granting the request stay will not cause harm to the appellee. The plaintiff appellee's interest can be protected without jeopardizing the defendant's appellant rights to a fair appeal. Public interest court consideration. Upholding due process rights is the public interest. Ensuring a fair and impartial appeal service and broaden goals of justice. And indigence of defendant. The defendant appellant is indigent and therefore should not be required to post supersede bonds. Conclusion. I formally request that the court grant a stay of proceeding pending appeal and, if necessary, waive the requirements for a superseded bond, or in the alternative, allow the defendant appellant to proceed with surety duty to indigenous. See attached proof for appellate court filing in attached exhibit. Closing. Express appreciation for the court's consideration of the motion and provide contact information for any further communication. Supreme Court case number is pending. I also reserve my right to amend this motion and more grounds to be argued or attendance. Thank you, Your Honor.
Okay, Mr. Butler, what's the people's position here?
Thank you, Your Honor. This motion is very similar, not identical to what he had previously filed, so our response will be the same. The only difference is that we have received an order from the Court of Appeals, and that was dated January 26th, in which the Court of Appeals dismissed the defendant's claim for appeal. So then the defendant did file then with the Michigan Supreme Court, and that same day that he filed, the court rejected his filings. So there isn't anything that's currently filed, appropriately filed in either the Court of Appeals or the Michigan Supreme Court at this time that I'm aware of. So we would ask that you then deny the defense now second motion for stay.
All right. So it is accurate that the motion before the court today is similar to the one that the court denied back in January 23rd of 04. At that time, there was a motions filed in the Court of Appeals. It was the court's belief that they were premature at that time. And then a January 26th order from the Court of Appeals dismissing those orders or that request for review as not being right in essence. And then Mr. Hensley Bay has filed something with the Michigan Supreme Court. I don't know what the status of that is. The prosecutor has been, hold on, sir, let me finish, and then I'll let you say what you want. And prosecutor suggested that those filings were not accepted. I don't see anything in the file whether they have or haven't, and it does not impact the court's decision regardless of what's going on here today. But if I could, in a thumbnail, identify the appeal that the request for stay that Mr. Hensley Bay filed earlier, this one today, are his attempt to have appellate review of different trial court decisions that were made during trial. And that review, again, I don't think is appropriate for any appellate court until there's a final judgment, meaning sentencing. We haven't got that far yet because of these motions. So again, I don't believe that there is any legal justification, a court rule that would suggest that the court is required to grant a stay. Court is not going to grant a stay for all the reasons I've stated on the record here, and that in essence, what Mr. Hensley Bay is attempting to have reviewed is something that can only occur after we have a final judgment, which is sentencing. And then the entire record of the trial, and motions and anything that occurred prior to that date can be reviewed then. And he'd have an appeal of right, as I've mentioned in the past, because of the verdict after trial. So it wouldn't even be the lesser request of a claim of appeal. I'm sorry, seeking leave to appeal. He'll have a right to review of the trial and all decisions that went into it. So respectfully, Mr. Hensley Bay, I'm going to deny the request for a stay here today. Mr. Butler, I'd ask that your office prepare an order indicating the same, and let's make sure so that it's easy to track, or as best we can, that the language that Mr. Hensley Bay has used is in that order. It's denying his defense motion for stay of execution pending appeal, bond to be waived. All right, that was filed on February 9th. And then Mr. Hensley Bay has promised, so I'm denying the stay, but do you have a question?
Yeah, I mean, the only reason why the appellate court, one of the reasons why they denied the motion, because I don't have the transcripts yet, and I don't have any information saying that the Michigan Supreme Court denied anything, because they.
Well, that's what I said. I don't have anything either. But so here's the thing: I'm denying the request today. Now, the Supreme Court, if they sign an order that says, "Wait, we're granting your request for a stay," then this court has to follow any orders that would come from the appellate courts. I don't have anything in the file that would suggest that.
Okay, but you do have my paperwork that I did file with the Supreme Court, and you have the numbers on everything The date that
Well,
I filed?
I have what you have titled Notice of Appeal to the Supreme Court of Michigan, and
Okay.
the case title is TBD, I assume to be determined. So
Yes.
that is in the file. It's received on February 9th.
Yeah, I can't do nothing until I get those transcripts though.
Okay, so next order of business then is Ms. Bond is here. We had a pre-sentence report completed.
No, not yet. He's scheduled for sentencing on March.
Okay, does he have a date that he's to report to?
I'm gonna actually make contact with him this afternoon.
All right. So Mr. Hensley Bay, absent some direction from the appellate courts, it sounds like probation will be contacting you to begin the process of completing the pre-sentence report. And what was our sentencing date?
March 5th.
So March 5th looks like will be our sentencing date. Okay? So make sure you respond to them and get that completed, because I don't want you to be violating the terms of your bond or something of that nature. And I'm not suggesting that you would, because you always appear and you're always polite and respectful. But they're going to be reaching out to you to get that scheduled and get a sentencing date. Okay, sir?
Okay.
Okay, you are free to sign off. Thank you, Mr. Hensley Bay.
All right. I come today and get that order that denial.
I didn't catch that last part. What was that?
That order that he denied, you denied. Can I pick that up?
Mr. Butler's going to prepare that order. I assume that can be done today. I'll sign it, and then it'll be filed at the clerk's office, and you are certainly welcome then to contact the clerk's office for a copy so that you have it for your records.
Okay, gratitude.
Okay, sir, you're all set today. Thank you.
All right.
I got nothing. I really don't know how to even respond to this kind of thing. Again, how he thought he was going to get away with it just because he starts using some fancy words that he pretty much can't pronounce is absolutely a mystery to me. But let me know what you think down below, folks, and we'll catch you in the next one. Sláinte.